Good morning, everyone. Thank you for joining us today. We are ready to get started, but we're going to wait just one more minute to be sure everyone has a chance to sign in. So please hold tight for the next 60 seconds.
While we're waiting, I should add that yesterday I was talking to a client and they said, well, you should have patent law for the trademark attorney. And I was like, yeah, that's a great idea. Maybe one of the next sessions.
There we go. All right, we're going to get started here today. Welcome everyone to the 24th installation of the Panitch Training Academy. Today, our topic is trademark law for the patent attorney, but as Steve just said, hold on, maybe a future presentation will be patent law for the trademark attorney. My name is Bridget Labutta, and as I mentioned, my colleague Steve Lustig is here with me. We will be presenting today on this topic. Steve and I are, as I like to say, seasoned trademark attorneys in the trademark law group here at Panitch and we've been practicing, I think, each one of us for over 20 years, but I'm going to leave it at that. Nobody needs to know more details other than that. We are very, very seasoned, have a lot of experience in this field, and hope that we have some good information to share with you today. This webinar, as well as all of our other 23 sessions in the Panitch Training Academy, are recorded, and they can be found on our website to view at any time. That's panitchlaw.com. If you have any questions during this presentation, please drop them in the chat or Q&A sessions that you see on the screen. Steve and I will be checking those areas throughout the presentation to answer any questions you have. And we will leave a few minutes at the end to answer questions that might pop up. If you are seeking CLE credit in Pennsylvania, Delaware, Georgia, Florida, or Virginia, please ensure that you answer the 2 pop-up polls that are going to be showing up on your screen during this session. And also, at the end of the session, if we would, we all kindly ask you to provide your feedback in the survey that's going to be sent to you at the end of the presentation. So with all that out of the way, let's get started. As I mentioned, Steve Lustig and Bridget Labutta are your speakers today. This is our information contact. We'll also put this up at the end so you know who we are and how to get in touch with us if you're just a little too shy to ask questions publicly during the session.
Also, if we meet at a business meeting and I'm wearing that tie, please stop reminding me that I have that tie in my picture. I can't wear the tie anymore. Anyway.
We have, I think, put together a pretty fun and interesting session today. These are the main subject areas that we're going to be touching on today. And if, again, you have anything new or different that you want to expand on, please feel free to drop a question in the chat or Q&A. So, once again, we are your trademark attorneys. And one of the first distinctions I think we should make between trademark law and patent law are those that may practice in these areas. Steve and I are both attorneys. We went to law school here in the United States. We took a bar exam in our respective states, and we practice trademark law. We file and prepare documents before the U.S. Patent and Trademark Office. But we are not patent lawyers. We, at least I personally, do not have a scientific background. I'm not a scientist, a PhD, or an engineer like many of my colleagues at Panitch. I'll let Steve speak for himself. But what that means for me is that I did not sit for the patent bar. So I have a state bar, multiple state bars, but not a patent bar. But nonetheless, I am eligible to practice trademark law before the USPTO. And that also means that as trademark attorneys, we tend to specialize, or rather not specialize, in a particular field. We have clients in almost every industry. So whereas you might have an electrical engineering patent attorney, My practice is not so limited. I can work with electronics companies, and I do. I work with retail outlets, consumer electronics, food, pharmaceuticals, all those sorts of things. And this might be a good time to just ask Steve maybe to introduce himself and his practice areas and how he distinguishes himself from patent lawyers.
Oh, thanks. Well, I usually distinguish myself from other attorneys by height, but aside from that, no, like Bridget said, I don't have a scientific background. My degrees are in political science and law, of course. But that doesn't mean that I'm illiterate when it comes to technical things. For example, I have a lot of clients in the automotive area, and I'm a shade tree mechanic. For those of you who are unfamiliar with the term, it means that I like to work on my own car. In practice, I work on my own car until I break it enough that I have to take it to my mechanic to have him repair what I've broken. But I can change oil and things like that. But it gives me the ability to talk to my clients about what is a camshaft or what is a piston ring or things like that. So it's not that we're illiterate in technical areas, it's that we just don't have a degree in those areas.
Absolutely. Yep, we are jacks of all trades. We know quite a bit about quite a bit of different industries. And then moving right into what is a trademark, we are hopeful that all the patent lawyers that might be listening to this session today have a basic understanding of trademark law, but it's always good to kind of go over it and to remind everybody what it is. A word, name, symbol, device, colors, sounds, or any combination of those things that any entity uses to identify their product or their service as coming from them or from a particular source. This right is connected to a business. So we're going to have, either an individual or a company that is providing that good and providing that service. And a little bit of a distinction from patent law, where patents are going to be protecting the inventor in their inventive rights. Trademarks, of course, provide some protection and service to the owner, but they are also going to be protecting the public from confusion. So we're both jointly protecting an owner's goodwill or their reputation, but also the public from confusion. A trademark, you might hear people say trademark, service mark, or just mark or brand. These terms are all synonymous. We use them all the time, Steve and myself, to refer to what we're doing to protect. But what you should know is trademark is not a verb. We
Can I
don't.
jump in on this one?
Yes, please. I know this is a sticking point for you.
This is my
Steve's
biggest pet peeve. Yeah. So the idea is very often you'll hear somebody say, "Oh, I want to trademark that," or "I want to. We should trademark that." So if you're the problem with using that type of terminology where you use trademark as a verb is you're conflating a lot of things. There's a distinction between the trademark itself, which is a noun. It's your brand or it's your source identifier. It's it's what's on your product. It's what's on your product packaging. There's a distinction between that and what you need to do to protect that and protect it well. So protecting it well involves registration. It involves possibly reporting your registration with Customs and Border Protection. So when somebody is in, let's say, a boardroom and they say, "Oh, we should trademark that," they've probably not been down the road before and they don't really know what they're talking about. In their mind, they may think, "Oh, we can extract this word from the lexicon and protect it exclusively." That's not what it is. Okay, trademark is a noun. It's your brand. It's not something you do. So anyway, thank you.
Yes. No, that's really good to know and good for everybody to be reminded of. You're always going to use some sort of phrase after your trademark. So you're going to say McDonald's restaurant, Coca-Cola beverage. So there's always going to be something after it. And we'll get into it a little bit later, but it's kind of a misnomer to say, even if you were going to use it as a verb and say you want to trademark this, that implies a registration. But you don't even need to have a registration to own a trademark. Again, we'll get into that a little bit later. But the benefit of a trademark is that you're going to be excluding others from using that same trademark on the same type of product or service or anything that's confusingly similar. Next slide, please. So we've got some vocabulary here, the first of which is confusingly similar, likelihood of confusion. These are phrases you'll hear trademark attorneys use a lot. Again, this is going to be an exclusive right to prevent others from using your same or similar mark on the same or related goods and services within the same geographic area. So it's a right of timing as well. Whoever's the first to use that mark has the priority and the rights to do so, and then to prevent or preclude others from subsequently adopting the same or similar trademark. So when we're talking about likelihood of confusion or confusingly similar marks, we're looking at, do they look the same? Do they sound the same? Do they have the same connotation or commercial impression? And if so, it could be problematic. Those two marks may not be allowed to coexist, and the prior user, again, could preclude the subsequent or junior user from adopting, using, registering that trademark. And so a big part of what Steve and I do in our jobs on a very regular basis is determining the level of risk associated with an intended new trademark before our clients try to adopt that new mark, put it on marketing materials, attempt to register it with the US Patent and Trademark Office. And we do that through a search. We're going to get a little bit more into details about trademark searches later, but just know right now that that's one of the things that we do and the services that we offer. I know on the patent side as well, there are patent searches, and it's a very similar goal when we're looking to search and clear a patent or a trademark before use or registration. Next slide. Trademarks are distinctive. Again, on the patent side, we're talking about patents needing to be non-obvious and new to the inventor. On the trademark side as well, we need things that are going to be marks, I should clarify. Marks and brands need to be distinctive to be protectable. And we have this spectrum here on this slide that shows you that distinctiveness spectrum. Something weak is going to be a generic mark. I mean, you're not going to be able to use or protect or register the term Apple as a trademark if you're just selling apples. If, however, you're using the term Apple to sell computers, that's a pretty strong and distinctive trademark. That's going to be something more arbitrary, because the term is a known word, Apple, but it's being arbitrarily applied to a service or product that is a bit unexpected. So of course, a fanciful or a coined word is the strongest type of trademark. That would be something like Exxon, Kodak. Those are brands that have no other meaning as words in the English language beyond a source identifier. But again, on the other side is something generic, or right above that, something merely descriptive that gives you an idea of what the product or service might be. But maybe doesn't directly tell you what it is. So those are marks that are a little bit more on the fringe. We have to consider them more carefully before we could, suggest or recommend to our clients if they want to use them or try to register them. Not to say that they can't be, but it's a little bit more difficult when your proposed mark is at that weak end of the distinctiveness spectrum. Next slide, please. Lots of types of trademarks. So just like patents, which you have a utility, a design patent, plant patents, there are also different types of trademarks. Of course, the most basic is a trademark itself, which is going to identify the source of goods, products, but also when you use the term trademark, it can identify or refer to services as well. But if you want to make a distinction, a service mark as a phrase identifies services specifically. But again, the term trademark can encompass both products and services. We also recognize collective membership trademarks and certification trademarks. The examples here are, Underwriters Limited, which indicates that that product or service has met certain standards that are set by the UL entity. The other symbol here, I believe that's the United Methodist Church. So that's going to indicate that the church you go to might be a member of this larger collective of churches that are governed or overseen by the same entity. Next slide. more types of trademarks. We have trade dress as well, which is a really important, but maybe less known or less understood type of trademark. And the two main types of trade dress are product packaging and product configuration. So again, the shape or outline of a container for goods, business premises could be product packaging, like the unique design and layout of a Mexican restaurant, for instance. And then product configuration is being things that are, color, brown. If you see the color brown on a package delivery truck, hopefully everybody's thinking UPS. They've done a very good job of creating some distinctiveness and some goodwill in the color brown for their services. Next slide, please.
Okay, so thanks, Bridget. Let me just add one thing about the acquired distinctiveness with regard to trade dress and colors. One of the examples I often use, and UPS is great, is Owens Corning fiberglass. So people know Owens Corning fiberglass as being pink, and they had an ad campaign with the Pink Panther cartoon character. For those of you who are my vintage, you probably watch that Saturday mornings or whenever. But the point is that just putting a color into the marketplace isn't necessarily going to distinguish your product. But after a substantial advertising campaign, then that can help educate the consumers, and that acquires the distinctiveness necessary to become for the color to become a protectable source identifier and trademark. Turn to this slide. If you're a patent attorney and you're tuning into this to learn more about trademark law, then you should know all of this, right? But the bottom line is, a patent is it's only right to exclude others from making, using, selling products. Utility patents, they basically protect inventions, and they have a limited duration, 20 years from filing for utility patents. For design patents, you're really talking about ornamental designs, and the duration is 15 years from a grant. The big difference between trademark and patent is, or one of the big differences, aside from the subject matter itself, is the duration of protection. So a trademark or a source identifier or brand, the life of that is the life of the business that it's being used in connection with. So it's a right pertinent to a business. It's a right connected to a business. As long as you are using Coca-Cola in connection with your beverages, you have protection for Coca-Cola. As long as you are using your brand in connection with your business, you have that protection. So the protection the trademark affords lasts indefinitely. And one more thing is that there is this, I don't want to call it the holy grail, but there's this upper echelon of trademark protection when it comes to trade dress, where a lot of sophisticated companies, they initially get a design patent for an ornamental design, and that protects you from the first 15 years. But then after the 15 years, they say, oh, well, we've been advertising it so much, we've been doing all this stuff. Now that product design is our trade dress. It's our product configuration trade dress. And if they can convince, let's say the Patent and Trademark Office, but also consumers, that that is the case, then that trade dress protection lasts well beyond the 15 years of the design patent.
If I could interrupt as well, Steve, excuse me. I just wanted to mention too that, we're contrasting US patent and trademark law, but there's a lot of dovetailing. The design patents and the trademarks work nicely together because the trademark is going to last indefinitely, or is so long as the product or service is being sold. Another really good example is plant patents. I work with a lot of companies that are developing new species of plants. They're able to get their plant patent, which again is going to be a fixed time frame of protection. For the plant patent, it's going to protect that variety. But then, we have a program where we'll file a trademark application to protect the brand used and associated with the client's plant patent. So that brand name is going to exist beyond the life of the patent itself. And so there's quite a bit of overlap in that way, which again, hopefully is not a super big surprise to everyone listening today, but just want to acknowledge that that's the case.
Thanks. So turning to the law itself, this is the, it turns out we've got a poll. So I'll wait a second while everybody completes the first poll for CLE credit. And... All right, so while that's up, I'll turn my attention to the slide. The Lanham Act, the U.S. Lanham Act. It was enacted in 1947. This is the modern law. There was a younger law, or an older law, rather. There are some cases where you have to merge the older rights into the new rights, and there are I don't want to say obscure, but there are provisions for doing that. But most of what we do today is governed by the Lanham Act. The Lanham Act really does two things. Number one is its goal is to create a one-stop shop for people to look at what brands are out there. And that's the US Trademark Register. And what that does is it makes it much easier for brand owners and for businesses to say, hey, I want to adopt a new brand. Let me look at this register and see if somebody else has something confusingly similar, because I want to steer clear of what they're doing. So that's the freedom to operate portion of it. The other part of the law is to incentivize registration. So you don't have to have a registration to have protection in the United States. As Bridget said, trademark protection is a subset of the law of unfair competition. And so, trademarks are protected just at common law without a registration. But to incentivize registration under the Lanham Act, you get some additional protections, which we'll get to in a second. But it makes it beneficial to register your mark at the federal level.
Before we continue on, we do have one question that might be good to address right now. Mia asks, so applying for trademark protection for a color or other trade dress may have to happen after use of the color in your business. Yes, because again, something else we'll get to in the future, but when you file a trademark application, just like a patent, it's going to be examined. And there are certain bases on which a trademark examiner would reject or refuse to register your trademark. One of which might be that it's not sufficiently distinctive. And so it might be necessary, if you get a rejection like that, to have already built up some evidence to respond to that rejection, and evidence of acquired distinctiveness, which might be, all the use that you've been making of that color or other trade dress, affidavits from customers that recognize your trade dress as your trademark, marketing materials, surveys, things of that nature. So it would necessarily have to happen after you started using the trade dress.
If I can just add to that. Yeah, thanks. No, that was excellent. Let me just add that in my experience, there used to be one examiner at the USPTO, and his name's Bill. I won't say his last name, but he was very attuned to the law surrounding color marks, and he would be very, very quick to reject or to refuse registration. One of the things is, color marks are not registrable unless you have acquired distinctiveness, which means by definition, you have to have use of the mark. So if you submit an application based on intent to use for a color, it's going to be rejected. The other thing, or it's going to be refused registration. The other thing is, don't waste your time trying to register the color black. In most cases, and I'm talking 99% of cases, black is considered functional, and there's jurisprudence on that. One that comes to mind is outboard motors. You have a black outboard motor; it can go with any type of boat. Just a pro tip: just don't waste your time on that. Anyway, back to the slides.
Yeah. Pro tips are very good too. The next slide, we're going to talk about common law trademarks, another good vocabulary term. Here in the United States, a trademark does not have to be registered to be enforceable. That Lanham Act does provide a provision for you to sue for unfair competition, which is a version of trademark infringement that says somebody else is using a similar trademark on a similar product, and it's causing some problems for me in the business, or excuse me, in the marketplace. So again, a mark used in the US need not be registered to be enforceable. So that's what we were saying before. You have a trademark and it exists, and you can call it a trademark from the moment that you first start selling that product or that service in your geographic area. And from that point forward, you have some rights and abilities to preclude subsequent users from infringing upon those rights. So there's some benefit just to get your product out there, to start servicing your industry, start using your trademark. And that's something we trademark attorneys rely on heavily in our business. We want to know what is the date of first use in commerce of that trademark. That's information we actually put in an application when we file it with the USPTO. So we need that first date of use. And so another element that we need to consider is there's two fronts on which you sometimes fight your trademark battles. We've alluded to these refusals to register or rejections that you might get in the United States Patent and Trademark Office. And that's one battlefield, so to speak. So a trademark examiner is only looking at its own records, only looking at what has been filed or registered on the trademark register at the USPTO. But the other battlefield, again, so to speak, is the marketplace. And so there could be confusingly similar trademarks that are not registered. They're not in the records of the USPTO, but there could be a problem because they're in the marketplace coexisting, causing consumer confusion. And that's something that in most cases needs to be taken care of in one way or another.
Bridget, can I jump in for a second? There was a question. So one of the questions that just came up was about registering 3D marks. 3D marks is another way of saying trade dress. So what you're talking about with the 3D mark is you're talking about a product configuration. So there's two types of, so there's product packaging trade dress, which is, if you go into an auto parts store and you're looking for a certain product and it comes in a box that's shaped like a penguin, you look for the packaging that's shaped like a penguin. Product configuration is Bridget's example earlier, which was the Coke bottle. You're looking for something that has a fluted design. So 3D marks are trade dress. It's either the packaging or it's the product configuration itself, and that would go through the same scrutiny that we discussed before, where you would have to have use of the mark in commerce. You would have to have acquired distinctiveness to get protection for that.
Yeah. And we actually use, I assume you do as well, Steve. When you file an application to register a 3D mark or trade dress, we have to submit a drawing of what the issue is. I actually use patent drafters for that. So you'll have, for instance, design of a restaurant's interior. There's certain elements inside of the restaurant that you might acknowledge are not protectable, and so those would be shown in dotted lines to show like, okay, we're not claiming that, but everything else in these solid lines, like the shape of a chair in relation to the bar top or something to that effect, that's how we would present those to the USPTO, and they would be shown in sort of a three-dimensional type style so that you could see all the dimensions that are involved. All right, so thank you. It took me a second to orient myself. Trademark notice, not required, strongly and highly recommended. When you see a brand with the symbol TM, which is usually presented in a superscript fashion in the upper right corner of a brand, either next to the word or next to a logo, for that matter, that's just simply indicating to the public that the owner claims trademark rights in that particular trademark. They could be registered, they could not be registered. That's not a factor taken into this notice that is presented as TM. However, if a trademark notice is being presented with an R and a circle, that does indicate the trademark is registered in the jurisdiction in which it's used.
Can I just jump in on that?
Yeah.
Yeah, thanks. Sorry. We get these questions all the time. Like, can I use the TM? Can I use the circle R? So circle R is registered. TM is registered or unregistered. We're generally talking about US law. And I want to make this distinction because in civil law countries, that is, you have common law countries like the US, UK, Canada, and you have civil law countries. Civil law countries, basically, you must have a registration as opposed to the common law where you don't need a registration. In some civil law countries, use of the TM indicates that the mark is protected, registered or not. And if the mark is not registered in that country, you could expose yourself to liability for basically making a false advertising claim. The idea is you're communicating to the public that this trademark is registered or protected in the country where it's not. So to the extent that we're talking about US law, this is what it's talking about. But to the extent you're conducting business internationally, sometimes you need to examine the laws in a particular jurisdiction before you can go and use these symbols. Comes up all the time.
It does. And we have quite a few clients who will choose, even though they have a registration in the United States, they may choose to use the TM because their products are shipped to different countries where they may or may not have registrations, or the validity of their registrations are in question. So just as a maybe a budgetary concern or consideration, and for marketing purposes, so they don't have to have different packaging for different countries in which their product is being exported, they might just universally use the TM symbol. We do have one question, again, might be a good time to pause and answer. Ramon asks, at the time of applying for registration, how accurately do we need to describe the details of a design mark? What are the legal consequences of being too vague versus being too detailed in the description? So another aspect of a trademark application, which you may already know, is that if it's just a word, you just put the word, you don't need to describe what it is. If there's a logo involved, you need to describe what the logo is. And as a practitioner, I do my best to say, okay, it's this word and a stylized font, and the color green is here, and there might be lines or stars over there. During examination, the trademark examiner will tell you if your description needs to be revised, and they'll tell you exactly how it should read. But it doesn't impact or affect the validity of the registration or the protection granted. It's just merely words to describe what the trademark is. It also is used to help categorize the trademark for searching purposes. So if it's got something with stars in it, there's a sort of like a Dewey Decimal System that tells you, okay, this is the search term for marks with stars, that sort of thing. So we do try to, at least my approach initially with any application, all the details are trying to be as all-encompassing as possible. And then, when the examiner is looking at it and talking to us about what needs to be revised, we can limit or narrow it a bit more. Steve, do you have thoughts on that?
Yeah, just addressing this this question, can you apply for a trademark word name in combination with other elements? Yes, absolutely you can. We call that a composite mark. It's a composite of the word, the literal element, and the design. However, there is a best practices here. There's another pro tip. The literal portion, the word portion, tends to have more of a dominant impact on consumers. Mm-hmm. The design element tends to be something that's more esoteric. So what we often, let me also add that if you get a registration that just covers the word in what we call standard characters, then that registration will cover the word in any font, stylization, color, whatever. Okay. So what we normally advise people is if they have both, then we submit two applications, one for the word and one for the composite. And the word protects you, the registration that will ultimately issue for the word protects you for anything confusingly similar with the word. The registration for the design protects you for, yes, the word and everything else and the design, but it really protects you against counterfeiting, where somebody tries to basically rip you off by copying your design. So we usually recommend both. One of the issues with registering a design as your trademark is that designs tend to change over time. Mm-hmm. So you must be prepared in the future when it's time to maintain the registration. Say, oh, well, we changed the design. Is it worth maintaining the registration, or do we now apply for a different trademark?
Yep. Before I hand it back to you for the next slide, I just want to finish up on this slide and reiterate, because I saw a question that went away, so maybe it was already answered. But again, to reiterate, it's highly recommended that you not use an R in a circle in any jurisdiction where you don't own a registration. So in the reverse, use R in a circle only where your trademark is registered, because you can get into trouble. And so as a default, at least use the TM, because that can be used in any jurisdiction, whether you're registered or not.
Right. Yeah,
all right.
No, thanks for raising that, because it does come up all the time. Some of you may have seen the principal register and the supplemental register. So what's the difference? So when you apply for registration of a trademark in the United States, you typically apply for registration on the principal register. The principal register is for marks that are distinctive, they're source identifiers, and consumers know them as source identifiers. So when they see them, they know this indicates the source of a product or service. The supplemental register is this special thing in the United States that we have for descriptive marks that are not yet distinctive enough to be trademarks. Now, you can't get protection for a generic term at all. If you're trying to protect soap for use in connection with soap, you're not going to get that even on the supplemental register. What the supplemental register is for is one of the examples I use is, and again, I'm a car guy, Indianapolis Motor Speedway. Indianapolis Motor Speedway, for those of you who don't know, is where they hold the Indianapolis 500. In the beginning, Indianapolis Motor Speedway was a descriptive term. It was a descriptive mark. It was a motor speedway in Indianapolis. But they've been running the Indy 500 there for over 100 years. So now it's acquired distinctiveness. The idea is if you have a trademark like that, you initially apply, you're going to get, and it's descriptive, you may be refused, but if your trademark is in use, then you can register on the supplemental register. And then what we do is we concede that it's descriptive, but then after 5 years of registration on the supplemental register, we don't renew the registration on the supplemental register. What we do, although you can, what we do is we say, okay, we're going to now apply on the principal register and say, hey, there's a section of law that says if we've been registered, been using the mark for 5 years, now we can apply for the mark on the principal register based on acquired distinctiveness. So those are the two different registers, and that's how they interact. Benefits of registration. There are a multitude, and one of the biggest takeaways from this presentation is register, register, register. You can have protection for unregistered rights, but the idea is if you were to go into court without a registration and you said, okay, this junior user is infringing my mark, the first thing the court would do is they would turn to you and they would say, well, you've got to prove to us that you have your rights. So now you're in a position where without a registration, you have to say, oh, well, here's testimony, here's documentary evidence, and you have to spend a lot of money convincing the court that you have the rights to even bring your case. With a registration in the United States, the registration makes your prima facie case, which is a fancy way of saying when the court turns to you and says, prove you have your rights, you submit the registration. You may even submit it with your complaint. We did that in a case yesterday. And then that convinces the court that you have your rights. Now they turn to the bad guy. In foreign jurisdictions, some foreign jurisdictions that are civil law, you have to have the registration anyway. So again, pro tip, register where you can, and to the extent your budget permits. The registration goes onto the register. It is kind of like an umbrella. People will be searching for similar marks that you don't know about, or they may apply for similar marks that you don't know about, and they may be refused based on your registration. So that's a serious benefit. I want to skip down to recording your mark with Customs and Border Protection. That's what CBP stands for, U.S. Customs and Border Protection. U.S. Customs and Border Protection will stop at the border, at the ports of entry, products that bear trademarks that could be counterfeit or infringing. They will only do that if they are notified by the trademark owner that the trademark is registered at the USPTO. So if you're in a business where you have a lot of, usually this comes up in the apparel business, we have a lot of stuff coming through ports of entry, it is worthwhile to not just register your mark at the USPTO, but also record that registration at Customs and Border Protection. And then, it's your tax money working for you. Customs and Border Protection will contact you in case they have any issues that they think you need to address.
All right.
Yeah.
I'm stoked by all these questions that are coming in because they always make sessions and presentations way more interesting. So a quick question that I want to address is, if you apply for a trademark for a name and it's refused registration for some reason, what risks do you face by continuing to use the name? So if it's rejected because somebody else is based on someone else's prior rights, then the concern there, of course, is that you could get sued, you could get a cease and desist letter. You know, there's always going to be a black cloud over your continued use of that name if someone else has priority. If it's something else, you know, if you're refused registration, and we'll get to a slide in the future that shows some of the reasons you might, but as a little preview, you know, you might be refused registration because your mark is primarily merely a surname. So you might not be eligible for federal trademark registration right now, but so long as you're not conflicting with another user, the risk is minimal for you to continue using it. And in fact, it might be to your benefit to continue using your trademark, because over time, that surname could acquire distinctiveness and be more suitable for registration at some future point. So you might want to use it and wait 5 years before you file your application. So that's, hopefully that's a good answer to your question.
No, it's an excellent answer. And let me just add, you know, when you talk about using risks, as trademark attorneys, we're in the business of risk management. Yeah. You know, what's the risk of using this mark if it's confusing and similar with another trademark? But this particular question is, what if it's rejected for another reason? Well, if your trademark application is refused registration because the mark is merely descriptive, like Bridget said, you could continue to use the mark. But remember, other people can continue using that descriptive term as well. So you're kind of on the horns of a dilemma. You need to, if you want to try and protect it, you can advertise it a lot. You can keep using it, and then after 5 years you can apply. But you're at the risk of somebody else saying, "Well, it's a descriptive term, I'm going to use it too," and then you can't stop them. Another thing is that if you apply for a mark and it's refused as being descriptive, that's all on the public record. Mm-hmm. So one of the issues there is that if you subsequently, I'm talking 10, 15 years down the road, want to enforce your mark against somebody else, if you don't have a subsequent registration on the principal register, a seasoned litigator or attorney or someone who knows what they're doing will examine the public record and say, oh, your trademark that you're trying to enforce was refused for being merely descriptive. We're going to use that as a defense. So that's one of the answers. But.
Yep. I'm going to jump through the next two slides because, oh, no,
there's a poll.
I'm going to wait for everyone to answer the poll. It should not take you long.
Well, we have 18 minutes left, so.
Yeah. You know, again, I really appreciate all the questions. There's another couple pending, but just to quickly get through the next two slides, I want to just touch on trademark use. In most cases, you must use a trademark to own it, to register it, to enforce it. There are exceptions, but use in commerce means you're using your trademark to sell or transport your goods out of state. We're talking interstate commerce that can be lawfully regulated by Congress. So you're providing your services to customers who live out of state, or you're selling or transporting your goods out of state. In order to register your trademark, again, in most cases, there's always exceptions. We're lawyers, it always depends. But in most situations, when you file a trademark application, before you can secure your registration, you must demonstrate your use to the trademark office. And those demonstrations of use we call specimens. So, you know, we're talking about if there's a product, the trademark office wants to see an actual photograph of that product with the trademark stamped right on it. If there's a service, the trademark office wants to see some copy of promotional material, like a website printout that shows the trademark being used to promote the services. So that's use in a nutshell. And Steve's going to talk a little bit about intent to use, the exception.
Well, so we've got this slide for specimens of use. I just want to touch on this a little bit. Very often we get asked, and by the way, this is a United States law idiosyncrasy. In other countries, you don't necessarily need use. This is U.S. law. We often get, you know, an application or even a maintenance renewal or something else where you have to prove you're continuing to use the mark, and the client says, "Oh, I'm using the mark. Here's the mark on a sticker." Well, use of the mark on a sticker doesn't necessarily mean you're using the mark in connection with an automobile or on jeans or whatever else. So you really need a photo for products. You need a photo of the trademark on the goods. So, picture of a Coca-Cola bottle with Coca-Cola. For services, this example that I'm giving you actually came out of the Trademark Manual of Examining Procedure. They have a whole section on what is acceptable and what isn't acceptable. But for services, here's a website example. The mark is in the upper left. The services are recited down below. That's an acceptable specimen for services. It's not just enough to say, okay, here's a document with the trademark buried in the text. That's not going to cut it. You really need prominent use of the mark and some connection between the mark and the services. So we only have a few minutes, so we'll go a bit faster. Trademark registrations, like Bridget said, you actually need use in commerce. There's an exception to that, which is intent to use. Intent to use is you have a bona fide intention to use a trademark, but you haven't started using it yet. So what happens is after you apply for it, if the mark clears examination, you don't get a registration. You get what's called the notice of allowance, and then you have 3 years to prove use. Once you prove use, then you get your registration. Another way to apply into the United States is apply in the United States based on a foreign registration. And you can do that either through a direct application or through the Madrid Protocol, which is a treaty. If you get your registration based on a foreign registration, then you don't have to prove use of the mark in commerce initially. 5 years down the road, 6 years down the road, when you have to file a maintenance document, and then thereafter when you have to file renewals, then you do have to prove use of the mark in commerce. So you just need to be aware of that. Trademark registrations, very rigorous examination, and unfortunately, you're kind of at the mercy of the examining attorney. We get examining attorneys who are very diligent and very zealous, and they issue refusals that we say, oh my God, are you serious? You're driving me crazy. So we always tell clients, budget some money to address refusals that may come out of left field. We do our best to craft the applications as thoroughly as possible, but it's always possible that you could receive one of these office actions, a refusal, maybe something made technical requirement. If that happens, you just want to have some money budgeted in reserve. Bridget already went over some of these carroted points that can lead to one of these office actions. Publication. In every country, applications get published for public inspection. What that is let's take the US as an example. In the US, you can have common law trademark rights. You don't have to have registered trademark rights. So what publication is about is, publication is a 30-day period, which can be extended, for anybody to raise their hand and object to the registration of a trademark. So it doesn't happen that often, but be prepared that you could apply for a trademark, for protection of a trademark. It could go through examination, and then it would go to the publication period. And during the publication period, somebody that you've never heard of before can object to or can oppose your application. This is another reason why we do clearance searches, which are basically freedom to operate. We just don't like those surprises. If there is an opposition, it would go to the Trademark Trial Appeal Board, which is an administrative court. I described what an opposition is. It's during the opposition period. Cancellation is, it's possible for a registration to be canceled for a number of reasons. If somebody misses the opposition period and they think that a registered mark is confusingly similar with their trademark that's unregistered, they can petition to cancel a registration. So be prepared.
And before we move on to the next slide, I want to bring up one of the questions that was asked, which was whether we could say a few words about concurrent use agreements. So I'm dealing with this situation right now. My client has a registered trademark on record with the USPTO. Another attorney reached out to me because my name is attached to the client's registration record, and said, your client's registration was cited by a trademark examiner against my client's trademark application. And this other attorney thinks that the marks are distinguishable and the goods and services and that the channels of trade are sufficiently different that we could coexist. So he reached out to me and said, you know, what we do in a lot of situations is propose a consent or concurrent use or coexistence agreement. And what that is in most cases, a simple agreement that just it's an acknowledgement between the parties that says our marks are different, goods and services are sufficiently dissimilar. And again, the channels of trade or the types of consumers that we're reaching are sufficiently different that we don't think that there's going to be a conflict in the marketplace. And so we agree both marks could coexist on the principal register. Now, if we sign that, it's submitted to the applicant's examining attorney, trademark examiner, who may or may not accept it. In most cases, it's accepted, and it's a way for that applicant to overcome the refusal to register. Now, in my particular situation that's pending right now, my client just isn't interested, doesn't want to respond, won't authorize me to respond. As a courtesy, I probably will reach back out to the opposing counsel and just say, we're not interested, because there's no obligation for us to sign it. There's no requirement that we enter into that coexistence or consent agreement. So that's how it is handled in some situations. In other situations, because the US, as Steve has been talking about, is a bit different. You know, you can file based on intent to use, and you can also file after you used a trademark for 10 years. So even though you might have a prior filing date or might have secured your registration first, that subsequent applicant might actually have a prior date of first use. And so one of the risks is if you don't enter into some sort of coexistence, they would have grounds to petition to cancel your registration based on likelihood of confusion and priority.
Which
So
dovetails,
yeah.
dovetails perfectly with this slide, because please finish and then I'll go on to the slide.
Yeah, no, that was it. I think that was good.
Okay.
We're kind of running out of time. We have a ton of questions, and I feel like we should focus on some of these questions as opposed to our slides, because they're just the real world inquiries that I think are really good.
Right.
And yes, you are going to receive a copy of all the slides.
If you haven't already. Incontestability, that is the holy grail of trademark protection in the United States. What that is if you file this affidavit under Section 15 of the law, the trademark office acknowledges that your trademark registration is incontestable. And what that means is it cannot be, your registration cannot be canceled except under very, very specific circumstances. So one of the specific circumstances is you procured your registration by defrauding the trademark office or something like that. Very, very fringe things. But with an incontestable trademark registration, as Bridget was saying, if you don't feel like granting consent, then you don't have to. And there's nothing the other guy can really do about your incontestable registration.
Steve, do you mind going back really quickly and answering a question about, you don't have to go back on the slides, but we have a question asking about what else customs can do for you to enforce a registered trademark?
Thanks for doing that, because I'm not getting the questions in real time like you are. So
No worries.
yeah, so there it is. So yeah, what customs does is, the way it operates is, customs they examine container ships when they come into the United States, right? And also they examine stuff that comes through ports of entry like airports. They can't examine everything, but they have a technique. For example, they know that if a boat leaves, let's say Hong Kong, goes through some ports that are known for counterfeiting, they have the bill of lading, they have the course of that ship, and they know that that's probably something they should examine. If they open up a container and it's filled with, let's say, wearing apparel, and it has all kinds of trademarks, Gucci, Dolce & Gabbana, Louis Vuitton, the whole thing, something smells fishy, right? No pun intended. So what they do is they contact the trademark owner's representative, who would be Bridget or I, and they would say, hey, is this counterfeit or is it genuine? And then we would go back to our client and say, is this counterfeit or genuine? They would tell us, and then we'd go back. And if it's counterfeit, we would tell customs, and customs would detain and then destroy the goods before they get entry into the United States. And they would fine the importer the MSR, the manufacturer suggested retail price of the goods. So it's a pretty powerful weapon if you're in an industry where things come through ports of entry.
Right. One more question on that subject from my old friend from Florida, Jack Abbott. When it comes to Customs and Border Patrol, do they enforce all registered marks equally, or do they give priority to those famous marks? Do they enforce famous marks more rigorously? Do you know?
I'm sorry?
With Customs and Border Patrol, the question is whether or not they enforce famous marks more rigorously than maybe
I see.
individuals' registration.
Sorry, I was I was looking at our time. The short answer is officially no, but unofficially yes. So I mean, the inspectors are humans like anybody else. If they're aware of a famous mark, then they'll be on the lookout for it. However, if your mark is famous, everybody thinks their mark is famous. If your mark is famous and you have not recorded your registration with Customs, then there is no nexus between Customs and your U.S. trademark registration. So if you haven't recorded your registration with Customs, they won't act because they don't have the legal authority to act.
Got it.
So
somewhat on the I keep punting these to you, Steve, but
sure.
Another question came up that touches a bit on famous trademarks. Somebody's asking or noting that in Canada, there's corporations that have prohibited marks where their trademark rights extend across all goods and services,
Yes,
and not
yes,
just
I'm
those they're
familiar with
selling.
that. It is the bane
Yeah.
of my existence. Yes.
So the question is
Continue.
whether we have something similar here in the US and how do we handle that conducting searches and estimating risk?
Yeah, so we don't have anything like that in the United States, and I can editorialize on that, but I will bite my tongue. What we do have is the law of dilution. Dilution is kind of a charged word. It means one of two things. There's whether or not a term is diluted. For example, Delta. Delta is Delta Airlines, Delta Faucets, Delta Dental. The word Delta or Sun or something similar is diluted. A lot of people are using it. The law of dilution is the law that protects famous marks. Now, everybody thinks their mark is famous, but it has to be really famous, right? Let's say Apple for computers or Google for search engines. The idea behind the law of dilution is if you see the mark Google on golf balls, in the consumer's mind, they're going to say, well, Google doesn't make golf balls, but I guess they're getting into the golf ball industry. What that causes is a blurring in the minds of consumers, and that is harmful to Google. So Google can take action against the golf ball manufacturer. That is what we have. We do not have the Canadian all-encompassing registration. So we have 3 minutes left. So let me advance the slide. What would you like to move on to?
I don't think that we're going to get through all the slides, which is a great problem to have because we really appreciate everybody's active participation. But to confirm, everybody should have gotten a copy of the slides. If you have not, please reach out to Steve or myself and we'll be sure to get a copy in your hands. We'll also be happy to answer any direct questions if you might want to follow up with us directly. The last question that I'd like to touch on, though, is the one about availability searches, because one of our slides was talking about searching. And deciding what level of search is required. You know, we can just search the records of the USPTO for a direct hit, a quick knockout search to see if that exact mark is already applied for or registered in the client's field of interest. Above that, we can use our own abilities to search in databases like Sagis to do a little bit more comprehensive search. I don't want to use that word, a little bit more thorough search. And then that higher level of searching is where we farm it out to Core Search or an outside vendor who will run the search for us. Steve's got a great picture there of these search reports. I'm having flashbacks to my first year of practice where all I did was look at these, 2-inch thick trademark search reports and provide opinions to clients. Those big searches are going to be for, higher risk activities. There's also a budget consideration. If clients are willing to spend the money, a couple of $1,000s to do the more comprehensive search, that is of course what we recommend. But if budget is a factor, or if the client's still a bit wishy-washy on whether or not they're going to move forward with that trademark, something more in middle of the road, in-house, we call it, it's probably sufficient for that.
Thanks. And I can't let the seminar end unless I address this slide. So I'm a baseball fan. For those of you who don't know these two marks, the mark on the left is Walgreens, the pharmacy. The mark on the right is the Washington Nationals Baseball Club. These two marks are coexisting, but the idea is that you can have diluted marks, the letter W, and they're coexisting, even though both parties sell clothing at retail or sell food at retail. There's just enough of a distinction between the goods and services, even though the marks are very, very similar. So again, this is freedom to operate for the patent attorneys out there. This is what we do with our clearance searches. So that's all I have. It is 10 o'clock. Bridget, any you're most welcome, whoever.
I'm answering some of the final questions that came through, but we just want to thank you all for attending, and thank you again for your active participation. We have more sessions coming up in the future. The next one is going to be May 15, tips for protecting and enforcing trade secrets. But keep a lookout, because Steve and I enjoy doing these presentations, so there'll be a lot more trademark ones to come.
All right. Thank you, everybody.